with Shakhan and Wilkerson Law Firm. Thank you again for joining us. Today we have a great topic that we're going to cover, and it is called contempt. It's something that you may have heard of, but we're going to discuss it here as it applies to the laws of Georgia. All right. Well, before we get started, again, my name is Genghis Shakhan. I do want to let you know this content is for educational purposes only. By watching this content, it does not form an attorney-client relationship between you and the law firm of Shakhan and Wilkerson Law. Okay. As always, you should consult an attorney. We'd be happy to talk with you if you are considering hiring or retaining an attorney. You're always welcome to give us a call at 404 999 9529 or 478-845-1213, and we will be more than happy to chat with you about what it will take to go forward with our representation. We do handle criminal law cases as well as family law and divorce, child custody, and men's rights. All right, now that that's out the way, let's go ahead and dive right into this meaty topic, which is known as contempt. Okay, so today we're going to talk about what happens when a contempt is filed, what it looks like to file one, what it looks like to be on the receiving end of a contempt action, and then, of course, how to protect yourself. The best way to protect yourself, obviously, is going to be to retain counsel. But if you don't have the resources, this is a great resource, this video, and just giving you a little bit about the basics and really how to move forward to either file or to protect you. All right, so now let's do a quick roadmap again of what we are going to discuss. We're going to define what contempt actually is, what it means to file, what it means to essentially defend against an attempt, contempt, what some of the consequences, things like jail time, things like fines, attorney's fees, or even things like if it's in the context of domestic relations. And that's what we're going to talk about mainly today is contempt in the context of domestic relations. It could mean things like if there's children involved, if it's a child custody case, your parenting plan can be modified if you're engaged in parental alienation, for example. It really just depends on the context, depends on the facts, depends on the parties, depends on the judge who even issued the order, or the judge that's hearing the case. If it's not the same judge that issued the order. Okay, so there's always a lot of variables when it comes to law. That's one of the reasons why folks do seek out counsel because we usually can sift through a lot of the facts, apply the law correctly, and usually kind of predict what an outcome, at least a range of where you might be looking at in terms of an outcome. Okay. So, as you may not know, if you already have a case, sometimes winning the case is only half the battle. Okay. And there's actually a court order that's put in place, and then there's the enforcement of that court order. Okay, and that looks different again in different legal contexts. So, for example, that might look different in landlord tenant, different in contracts, or in a business context. But we're going to get and talk about it from a domestic relations standpoint. Okay, so there has been an order that's usually issued, and then there is someone that is accused of violating that court order, all right, that has been signed by the judge. And so again, the consequences they can range from, as I talked about, jail time to fines, to essentially some type of admonishment, and it just really depends on again the situation. So we'll talk about contempt. We'll talk about what it means to be held in contempt, how it's proven, how it's purged. We'll talk about the penalties as we discussed, and why an attorney is going to probably be necessary and helpful, especially if you have a very complex case. If the stakes are high, it's always great to bring some counsel in. Okay. All right. So let's just come up with a simple definition. This is as simplistic as it is. It basically occurs when someone willfully violates a court order. And that language, as most legal language, is significant. I want you to, the operative word there is willfully. Okay. And so we'll come back to that. That will be a common theme throughout today's talk. Okay. So um what willfully essentially means is that, did you, and I'll get to the willfully part, but the court usually wants to know, did you know about the order? That's important. If you are accused of violating the order, and did you have the ability to actually comply with the order? And then did you intentionally fail to comply with the order? Those are usually the three questions that the court is asking itself. So let's talk a little bit about this from a common law perspective. And so one, not common law, but a family law perspective. So one thing, and let's talk child support in child support context. Okay, so in the child support case, there has been a child support order that has been issued, and the court now wants to know um, why this party has failed to pay the support. The court is going to ask those three questions that we just mentioned. However, let's just say that a person pays part of the support, they're not paying all of the support, or they're just making repeated late payments. That could be a situation where that party essentially is in contempt of court. There was an order issued. That order said, hey, party X is supposed to pay $500 a month in child support. Party X does not pay that $500 a month in child support. And yes, we do handle Cobb County cases. We are live, but yes, we do handle Cobb County cases. Thank you for asking. So the child support is not being paid by party X. And then, so another scenario where $500 child support obligation is ordered, and the party is paying $250. That person is not meeting the court order standard, and so that party might be held in contempt, or there just might be repeated late payments. It's not that the party is not making the payments, but the party was instructed to pay those child support payments on the first or at the first and 15th, to the tune of $250, or just they were supposed to pay it on the first. And instead of paying it on the first, they're paying it on the 20th, or they're paying it 3 weeks late every month. That might be another context in which you're looking at a violation of the court's order. Now let's talk about custody and visitation. So I'm giving you different contexts. The first one was in a child support situation. This is going to be child custody and visitation, and this one you probably heard a lot more about when it comes to actual contempt action. Is when a party is denying another party, maybe the non-custodial parent, access to the minor child. They're refusing to participate in the exchanges when there's parenting that's supposed to be happening and taking place, or they're failing to return the child. Okay, and that might mean they're failing to return the child at the designated time. That might be a context in the child custody or area and arena of contempt actions. And then you might just have parenting plan violations. That's another unauthorized travel, refusing communication, ignoring decision making provisions. That might be a context in the parenting plan violation situation. Then you can have divorce decree violations, failure to refinance a home, right? Following a divorce, you had a timeline. It was supposed to happen within 120 days. That 120 days has expired. You guys, you did not refinance the home. You're not making any efforts to refinance the home. That might be a context in where you are in danger of violating the court order and can be possibly held in contempt, or you're supposed to transfer property. Maybe you're supposed to sign a quick claim deed, and you neglected to do that. You're supposed to transfer property, the interest of property, failure to divide your retirement accounts, or failure to pay debts assigned by the court. Those are all contexts which you could potentially be held in contempt. And then here's the last one is alimony, right? So you've been ordered to pay alimony. One party is missing payments. They're making partial payments, or they're just repeatedly in non-compliance. Those are situations and contexts within domestic relations, family law, in which you could be held in contempt. So there are a lot of scenarios where a party might be held in contempt. And so I wanted to cover some of those remember, this is, the law is far reaching. This only applies to really family law type of situations. And so I wanted to give you examples in which the other party might be held in contempt. So let's talk about what needs to be proven in order to prevail if you file a contempt action, right? So first, you must show that there is an actual valid court order. That's really easy to do. You just have the court's order with the signature. That essentially lets the court know that there was an order in place and that order is valid. It's not expired. It is basically presented to the court in a timely manner. And the other party knew about the order, right? So maybe it was part of a divorce decree. So if it's part of the divorce decree, and that other party, essentially went through the divorce, then it's pretty obvious they were aware of the order. Sometimes, these cases move forward where one party is absent, and so that final order might not get to the other party. That happens, and sometimes, it happens a lot in cases like child support cases, where the non-custodial parent may not be participating in the actual proceedings. An order is issued, and you may or may not be aware that that order was issued. So you can very easily be in non-compliance. Okay. Then you have to show that the order was violated. That's pretty easy. If again the order was issued and the person that is supposed to be following that order is not following it to the letter, then they could potentially be said to be in violation of the order. And then the last one can be a challenge, though. This is usually the hurdle that I see folks kind of really struggle with. And you have to determine whether or not that violation was willful. Okay. And so if sometimes, for example, there can be an order in place, but the person might not have the resources. The person might have recently gone homeless, right? They may be on the street. They may be sleeping under a bridge. They may not have, again, if they don't have the income to, if we're talking about a child support order, then the court is going to probably take that into consideration, right? They are in violation in that they are not paying the amount of child support that they are paying, but they're probably just going into arrears. So it's not that they're not on the hook for that money. However, the willful component, all right, the willful element does need to be satisfied, and so that's something that you absolutely want to think about. Okay, and so if the violation was willful or not willful, here are some common defenses. To that willful element, right? Then that just talked about one of those is there's a genuine inability to pay. Okay, someone's lost their job, right? Someone is involved in a catastrophic accident. All right, someone is let's say forced to move, or they just retired, right, and they don't have access to the money and assets that they had previously had. There can be a genuine inability to pay. Okay, which might make the contempt not mean that is not they're not in contempt. Just means that they may not be in willful contempt as far as the court is concerned. There might be a lack of notice. Okay. It can be an ambiguous court order. People were a little confused about the court order. The court order can say, hey, you're supposed to pay $500 a month in child support, but it doesn't designate a day, right, when that's supposed to be paid, right? So, it can happen any day within the month. And so sometimes, a person that might be relying on that child support may need something more consistent and concrete in terms of a time and date of when they're going to receive those resources, and that might not be in the order. Okay, so sometimes orders can be ambiguous or missing information, vital information, that can help someone decide whether or not there actually is a valid contempt action. Okay, and so or it might just be a situation where compliance is impossible, right? So you can be, for example, a judge can say, hey, you have a alimony of $10,000 a month. However, you don't have $10,000, let alone is something that you can pay on a monthly basis. And so that might be something that needs to be discussed. and might need to head back to court to get that addressed. Okay. And so I want you to understand that not every violation is a contempt, right? Or even if it is a contempt, it still might not be deemed a willful contempt. And so that's important to know before you hire counsel. You bring somebody on, you got to do a cost benefit analysis, because there is a obvious cost to retain an attorney. You do want to put yourself in a situation where you are going to prevail and is going to be worth your time. You're going to get a return on your investment. So there are the very technical violations of a contempt. So, for example, you're supposed to get let's say child support on the second of every month, and the party is paying you on the third of every month. Well, technically, they are in contempt of the order because it's supposed to be on the second. However, going into a courtroom, I don't think a judge is going to hold the other party in contempt by because they are missing the deadline by 24 hours. And then you have to ask yourself again during the cost benefit analysis if it's worth actually fighting over in the courtroom, because of their resources, the time that would need to be invested in moving that case forward. Okay. So something to think about. You always want to do a cost benefit analysis when it comes to beginning a case and then bringing an attorney onto the case. All right. So there's civil contempt, there's criminal contempt. A civil contempt, of course, is basically there to force the party to comply if they are not in keeping with the order. So, for example, to pay child support or to return property or to follow the parenting plan. And then there's criminal contempt, and that contempt is used to punish, right? To punish misconduct, intentional disobedience, repeated violations, and disrespect of the court's authority. Okay. So now, what does it mean to purge a contempt? Basically, purging contempt is to resolve the contempt, to deal with the contempt, to bring the party that's not following the court order, to bring them back in alignment, and so basically, it's the way that a party fixes the problem. Okay, and the court usually can give a party a way to fix the problem. And so a lot of times, the folks that are being held in contempt do hold the keys to purging the contempt. All right. So some examples might be if you're in arrears in child support to pay those arrears. All right. Or to return property or sign documents that you were supposed to sign, or to comply with visitation, right? So if you are engaging in parental alienation, you're engaging in just being disruptive when it comes to custody and visitation, to basically come into compliance with the court's order, you can purge the contempt. All right. So again, the person that is accused of being in contempt usually holds the keys here. And so I want to talk really briefly about some of the possible consequences of contempt. And I mentioned this in our roadmap. One is going to be attorney's fees, right? So if you're obviously you're treating the court as a revolving door. We're back and forth. We're going before the judge, saying to the judge, "Hey, this party is in contempt. They are violating your court orders." One of the things the judge might do is they can order one party to pay the other party's legal fees. Okay. And obviously, as you know, attorneys are not cheap. So it's something that you do want to avoid playing games, because the court can hold you in contempt. They can say, hey, you're on the hook for this party's attorney's fees. And on top of it, still address what's going on with the contempt. They can, any kind of court cost, right? So if there's a cost associated with the litigation, you can be on the hook for that. You can be fined, or you can have, things like the other party might get makeup parenting time if it's a child custody matter, right? So you've kept your child away from the non-custodial parent for, let's say, 3 months. The judge may say, okay, well, over those 3 months, we're talking about, I'm just going to come up with a number, 21 days. So the non-custodial parent now has 21 days of makeup time that they can exercise between now and the end of the year. Okay. And so that's a possible outcome as well. Your wages can be garnished, right? You see that a lot in child support cases, um, um, and then other types of cases where there are maybe a business is being held in contempt, and there might be wages that are being garnished. Okay, and then modification risk in child support context, excuse me, a child custody context. If one parent is engaging in parental alienation, the judge may say, "Hey, you know what? Let's just go ahead and do a custody swap, because clearly you can't handle being the custodial parent. So let's go ahead and make the non-custodial parent the custodial parent, and now you can exercise visitation, and we'll see if that works out a little better." Okay, and so that can happen. I've seen it happen. All right, so you want to be careful when it comes to custody stuff, and then jail time. Right, so we have advocated for folks to go to jail that are essentially messing around with our clients' parenting time. Right, if they are keeping because we don't play about kids, we don't play about children. We believe that children, to be well rounded, they need both parents to be involved in their rearing. Okay, y'all both were involved in making the child, so you both need to be involved in raising the child. All right, and so, and if you this is kind of personal, but if you felt that this person was qualified to lay down with and procreate with, then that's your guy or that's your gal, and you need to find a way to co-parent and do so successfully. Okay, that is my personal bias toward that. All right, so modification risk we talked a little bit about, but jail time is something that again is on the table. Something you definitely don't want to see happen. And you can be jailed for anything from and non-custodial parents can probably attest to this that are watching this video. You can be jailed for child support arrears, right? And obviously it can impact your driver's license, and whether or not you can get your passport validated. And so orders, if your orders are being repeatedly ignored, or the violation is intentional, a judge can find you in contempt, and a judge can detain you. And if you're incarcerated, they can order you to be incarcerated until you purge that contempt, right? Until you're again brought back into compliance. All right. Now, what happens? Let's talk a little bit about what happens at an actual contempt hearing. Okay. So the judge usually will want to know what did the order require? And usually you're going back before the judge that issued the order, but not always. But a lot of times we are back in front of the judge, for example, that handled the divorce, the judge that handled the custody modification. And so it is their order that they are looking at. They're looking at their signature on that court order. And they may remember you, and that might be good and that might be bad. So you want to think about that as well. They may remember the exact context. May remember everything they told you not to do, and if you did the things they told you not to do, then they may feel some type of way about that. Okay, so you want to keep that in mind. They'll want to know what happened, and they'll also want to know usually why that court order was not followed. Okay, so the evidence usually is going to include things like the court order, if there are text messages, emails, payment records, if there's other testimony, or bank records. Those things are going to be used as evidence in those contempt cases. Okay. And so if you're filing for contempt, these are the things that you want to think about when you're gathering that type of evidence. All right. The court orders, screenshots, emails, financial records. You want to create a timeline. Okay. And then that's going to essentially, you want to tell your story when you get to the court if you're filing this action. And then you want to let the court know why that other party is not in compliance. Okay, you do want to, of course, focus on the facts. And if you're defending against a contempt, then you do want to talk a little bit about why you are not in compliance. Okay, you don't want to ignore and just kind of put your head in the sand. Like a stork, you want to gather your own supporting documents, and then you want to show good faith, right? You want to let the court know that, hey, you understand this is the order, and why you could not, fulfill your obligation, and essentially argue that your contempt was not a willful one. Okay. Now, here are some of the biggest mistakes that we see people make when it comes to these types of actions of waiting too long, poor documentation. They're violating orders out of anger. One thing we see is, for example, if one party is not paying child support, they may withhold visitation. All right, and so start engaging in parental interference, or vice versa. Someone might be, withholding the visitation, and the other party just refuses to pay child support. All right, can't do that on either direction. All right, and so both of you can be held in contempt, or again, if it's happening one way toward the other, that one party can be held in contempt. If the party is not paying child support, then you need to seek a contempt. If the party is not exercising, letting you exercise your visitation, and you are considered the legal parent, if you guys were not married, then you need to seek a contempt action. Important note here: if you guys are in Georgia and y'all had a child out of wedlock, and you did not have a go through the legitimation process as a father, then you don't have any rights, okay? Because you are not considered the legal father. And so there is no contempt. That party is not in contempt if they are not allowing you to essentially exercise visitation, even if there is a order in place for you to pay child support. Okay, that's something that you want to keep in mind. All right. So violating orders out of anger, self-help remedies, all of those things you do want to avoid. Definitely avoid pulling up on people who maybe are not allowing you to exercise your visitation. That turns into different type of legal situations for things like temporary protective orders, aggravated stalking. So you do want to make sure you're going through this process the correct way, so that you're not hiring us instead to address your civil matter. You're hiring us to address your criminal matter, which your freedom is on the line, which can absolutely impact the civil case that you have going on with custody. Okay, so you want to be smart, avoid the self help stuff. Just hire an attorney, guys. Just hire an attorney. I understand you may, again, you got to do the cost benefit analysis. If this is important to you, that means it's high stakes. Then just hire an attorney. Make sure it's done right. Okay. All right. Um, since I'm talking about hiring an attorney, let me tell you why attorneys matter in these types of situations. The attorney can draft the contempt action. They can argue the action. They can organize the evidence. They're going to present your case in the best light possible, and then they can request the appropriate remedies. Okay, so an attorney is going to hopefully make certain that they either are playing offense on your behalf, or they're playing defense on your behalf, depending on what side of the action you're on, and they are advocating for you, and they are advocating zealously, right? And so that is something that our office does, and I'm confident that other attorney offices do that as well. But of course, I am partial to myself and Attorney Wilkerson. We take, especially when it comes to co-parenting, we take that stuff very, very seriously. And we want to make sure that the babies are taken care of and protected. And so, if you are engaging in things like parental alienation, or you're not paying your portion of the child support, that stuff is not cool. And so we make sure that we advocate for our guys, so that they can absolutely exercise their visitation rights. Okay, so if you're defending against this type of action, it's going to be important that your counsel raise all the legal defenses, challenge all the allegations, negotiate potential resolutions, and help avoid unnecessary penalties. Okay. And then the same thing if you're on the filing side of this. Again, they're going to organize evidence, present the case as best possible, and then seek attorney's fees. Okay, if that's going to be a thing. All right, guys. Well, just keep in mind, court orders are not suggestions. Okay, as we wrap up, these are not suggestions. These are directives. The court is telling you this is what you're going to do, and the expectation is that you're going to be in compliance with it. All right. And so, as always, if you have a situation where there's a court order for child support, and the amount, you can't pay it because maybe you've lost your job, you've had a change in your employment status, or maybe you've taken a pay cut, and that pay cut was not something that was willful, because sometimes you'll see that people will intentionally be underemployed so they don't have to pay the child support. Then you might be right for a modification, right? And so rather than go in contempt, because you go in contempt, those arrears are still going to continue to add up. You might want to seek a modification. And that's something that we can help you with. We can also help you with the contempt. We can help you file the contempt. We can help you defend against the contempt. Okay. You have our information. Hit the link in our bio. Head off to our website. A lot of blogs. Well, we've written some books. They're available on Amazon. You can, I think, find them at the bottom of our website. If you need a consultation, give us a call, 404-999-9529 or 478-845-1213. You should be able to see that in the link. And thank you for joining us. We're talking about contempt, everything contempt today. And you have been a wonderful audience, and we will see you at the next video. Take care, guys.